So it is 11:15 my time, and I'm a night owl anyway, but this is unusual for me. And Shelly's not even aware. Shelly's sound asleep at her house at this point in time. But and I'm not even sure that anybody's going to show up for the conversation, but I'm going to record it because I feel like I have to get my opinion in on this matter. So a couple of things. No, actually, there's only one thing. Today, Mr. McCracken on his website released a copy, an unfiled copy of a motion that was submitted, that is going to be submitted. Now, I'm looking at. Well, let me just share it with you. So there, right. So this is a motion that was submitted by the estate. And I'm still a doubting Thomas, Mike, but too much conjecture and hypotheticals in what you're saying, but that's neither here nor there. So this is McCracken. Mr. McCracken shared this on his in his forum, and I can tell from the information that's on here, it hasn't been filed yet. It looks like what happened is Mr. Summers composed it and then shared it with Mr. McCracken, and Mr. McCracken shared it with the world. I don't know if there are any laws broken in that case, but that's what happened. So I can tell it hasn't been filed on it yet because it doesn't have the court's stamp on it with a time and date and things like that. I imagine it will be filed tomorrow, but the bottom line is Mr. Summers, on behalf of his client, the estate, explains that he's asking for a motion to delay the discovery deadline, especially in the case of the deposition of Mr. Stoof. And he explains why. These paragraphs 1 through 4 basically explain why. But one of the reasons is that he got an email from attorney Nasco, Tom's attorney, and Tom's attorney, and he incorporated this email, and that's why I can share it with you. It otherwise could not be shared. Tom's email to Carl, I guess I should go by Mr. Nasco's email to Mr. Summers, basically said that, well, you can read it. I just finished a conversation with representatives of the United States Solicitor's Office. The government is justifiably concerned about the disclosure of the location of found treasure. They still believe that Mr. McCracken is going to ask for the location. Though through the compelled deposition of my client. Now, remember, it was Summers that compelled the deposition. McCracken just is basically taking advantage of it. So he said that this attorney called him, and the resulting potential for damages to government property in contravention of 54 U.S.C. 100-751 and 36 CFR 203A3. The referenced authority implicates potential criminal responsibilities. As a result, I respectfully request that you continue the deposition, meaning delay the deposition scheduled for tomorrow, May 12th, from tomorrow, May 12th, to allow sufficient time for me to file a motion for a protective order prohibiting testimony concerning the location of found treasure. Thank you for your cooperation. Exhibit A is the email, which I'm not going to share with you. It's down at the bottom here. So again, Summers goes back. Petitioner McCracken has publicly indicated that he fully intends to request Stoof to disclose the location. The estate has no intention of asking Stoof where in Wyoming he found the chest. The estate and Stoof, through counsel, have rescheduled the deposition of Stoof to May 31st. Now, since it was Summers who compelled the deposition, he has a right to ask for a delay. He also has to state that Petitioner McCracken has informed him that he's going to oppose this motion. So that's where they are. That will be the judge will probably he'll probably indicate whether the motion is denied or not tomorrow. But of course, that doesn't leave much time for them to conduct the deposition if he doesn't. So there are some things that bother me about the email, and I think they could very well be simple mistakes on the part of Mr. Summers, but then I'm surprised. So there's a couple of things. The first thing is he says, I just finished a conversation with representatives of the United States Solicitor's Office. I know, and all you have to do is look up United States Solicitor's Office, and you're not going to find anything. The office is the Office of the Solicitor General. And the reason that's weird is the Solicitor General is responsible for defending the United States, either defending for or against the United States in the Supreme Court. That's the only thing the Solicitor General does. He doesn't involve himself with, he doesn't involve himself with any case that isn't going to the Supreme Court, because that's who he represents. He's the attorney that represents the United States in Supreme Court cases. So if I manage to say that my rights my privacy has been infringed upon because the government wants to know how many guns I own, that would go to the Supreme Court. I would have an attorney representing me, somebody who's probably spoken in the Supreme Court prior to this, had been involved in the Supreme Court case, and the Solicitor General's office would be representing the United States in the matter. So I don't understand why he would put that in, and he didn't even make it complete. He said United States Solicitor's Office. There is no such thing. It's the Office of the Solicitor General for the United States. And that office only deals in Supreme Court cases. So no matter how low you get in that organization, you're not going to find somebody that's going to be dealing with a case like this. So that was the first thing that bugged me about it. The second couple of things that bugged me about it is he didn't even take the care to, in contravention of Title 54 U.S. Code 100751 and 36, Title 36, Code of Federal Regulations 2031, the referenced authority implicates potential criminal responsibilities. So basically what he says is that this solicitor, this office of the solicitor, threatened his client that if he were to reveal that information, he would use these laws, one law and one regulation, to go after his client with them, right? Damages the resulting potential. The government is justifiably concerned about the disclosure of the location of found treasure, though the compelled deposition of my client and the resulting potential for damage to government property and contravention of those two things, the referenced authority implicates potential criminal responsibilities. Yes, as a result, I respectfully request. So he didn't actually say the government is justifiably concerned about the disclosure of the location. He doesn't say that the government is threatening anything, but he wants to he's asking for time to get a protective order prohibiting testimony concerning the location of found treasure, which is good. But again, there's several errors in here of several mistakes that I would look at, and I would say to myself, wait a minute, this doesn't sound right. United States Solicitor General, the government is justifiably concerned about the disclosure of the location of the found treasure through the compelled deposition of my client. So sure, but we know that the government is concerned. They already told us that when Ms. Bell mentioned that in the last hearing. The resulting potential for damage to the government property and contravention, the referenced authority implicates potential criminal. As a result, I respect. So there is no threat in anything that he is saying. And I looked both at, I'm not going to show you the bottom one, number 4 in this list, but there is nothing in anything that says the government threatened to punish my client. He just says they're very worried about it. And they might, and they threw these laws at me. Well, that's the third thing that bothered me. The third thing that bothered me is he cites 2 non-existent laws. USC 54, Title 54, US 751 deals with, it doesn't deal with national parks. And 36 CFR 2031 deals with boating, I think. Neither one of them have anything to do with the protection of national park properties. What he probably meant, and this is where, so here he says 54 USC. So USC is US code. Those are laws. Those are laws that have been codified. They've been passed by Congress, and they're now laws, right? And they're in the the United States Code. CFR is Code of Federal Regulations. Federal regulations are regulations as built. So the government writes a law, they turn that over to an agency, a department, and then the department interprets the law and creates regulations associated with that law. So it's two different things: U.S. Code, Code of Federal Regulations. Now, there is a Title 54, and as a matter of fact, I mentioned it a couple of times last week when I was talking about these things, and there is of the United States Code, and there is a Title 36 of the Code of Federal Regulations. But the following numbers don't match. They go to places in the code that have nothing to do with what he's talking about. So I went around looking for them. Here's the first mistake he made. He said 54 USC 751. What he meant was 54 USC 10021, which deals with damages, right? And I think he gets it right in one case. Let me go back here. He says 751. Yeah. So 54 U.S. Code, this is laws, deals with damages to property that's owned by the government. Okay. It also cites system unit resources as a definition. So if you remember correctly last week when I was talking about the U.S. Code 751, I'm sorry, 54, Title 54 U.S. 721 is the SERPA Act that has been so prominently talked about. Here's that law. So that down here you can see right here, right? Public Law 113-287. That's where all this is defined. And so if you go to Public Law 287, here it is, and you go down, so you have to scroll down because they give these paragraphs numbers 100, and they keep going up and up and up. So I think I'm at page, I'm going to raise it here just so at page 14 of the law. Let's see. Yes, 706, 707. We scroll down, 722. Here is 721. Subchapter 2, System Unit Resource Protection. So this is the subchapter. This is the one that we talked about where if you do damage to a system unit resource, something that's been defined by that agency as a system unit resource, you can be punished for damages, right? Now, what's interesting about this thing is this particular public law. I'll show you at the top here. Let me scroll down quickly here. National Park Service and related programs. Now, the related programs is kind of a sticky wicket because, for example, the National Park has the authority to define a system unit outside of a park. It doesn't have to be inside of a park. It also has the authority. So if you have a lake, and if you own private property inside a park, they can define it as a system unit resource. Let's say you had private property and there was an old cemetery on it. They could define that as a system unit resource above and beyond the fact that it's park property and you could get punished for doing things. So that was the third thing that bugged me about the motion is he didn't get his citations right. The second citation, 36 CFR 2031A3, is also incorrect. That should read 36 CFR 2.31. Let me show you 36 CFR 2.31, trespassing, and then he further cites it. I think he got the second part correct. So let me go back. So 36A3. So 36 CFR 2.31, not 2031. 2031 doesn't exist as a paragraph. A3, vandalism, destroying, injuring, defacing, or damaging property or real property. The several things that bother me about this is there is no place in that email that indicates, and maybe the judge will see this, there is no place in that email that says the government, the United States government, who should be not the solicitor, the office of the solicitor. He had the office of the solicitor. If he made that mistake and he just said the office of the solicitor called him, unless he's in a Supreme Court case, There is no reason why the office of the Solicitor General should call him. None whatsoever. Secondly, he never states in the email, I just finished a conversation with representatives of the United States Solicitor's Office. He should be talking either with the Department of Justice or the Department of Interior legal branch. This is not a Supreme Court case. For God's sakes, it's a probate case. I just finished a conversation with the United States Solicitor's Office. The government is justifiably concerned about the disclosure. And again, they express concern that is justifiably concerned, right? Let me get it back up here again. Is justifiably concerned about the disclosure of the location of the found treasure through the compelled deposition of my client. So I'm worried. So some attorney called him, some attorney that usually files, that operates in Supreme Court cases. And he said, I'm really worried about Jack bringing up the location of the treasure, right? But he stops there. He doesn't say, and we are going to prosecute the hell out of him if he reveals that. That's not what that says. The government is justifiably concerned. Disclosure, federal treasure, the compelled deposition, the resulting potential for damage to government property and contravention of, I didn't get those right. The referenced authority implies potential criminal responsibility. The referenced authority. The referenced authority in this case are the two citations that he incorrectly typed. So he says there is authority in these two citations to punish Jack Stoof. And a guy from the office of the solicitor called me, but he didn't make that threat. He just said, I'm pretty concerned. And again, if it was the office, first of all, there is no office of the solicitor. There is the office of the Solicitor General of the United States. The Solicitor General of the United States deals with Supreme Court cases, doesn't deal with probate and being concerned about land utilization. Unless it made the case, unless where the Solicitor General would be involved is Jack saying you can't charge me. The government charges him, which it doesn't sound like it's happening. The government charges him, and he takes it to the Supreme Court and says, "Wait a minute. All I did was dig up a treasure. Show me where the damages were, because I covered it up really, really well, and I put the leaves back in place." It doesn't make any difference where it was. And so there are several things that bother me just in the email. Now, the deposition that Mr. Summer is filing is a good deposition. I'm sorry, not deposition, but a motion that Summer is filing to request a delay. Seems hanky to me, because he's using the email as the reason for the delay, and the email is wrong. There's nothing in the email that says the government is threatening my client. And just the basic mistakes of using the quote office of the solicitor, no such thing. The quotes of the codes that he cited, incorrect. There's something, I think, I can only imagine that. Here's what I think is going on. Let me give you my opinion on the matter. Summers knows how the judge feels about the U.S. intervention, and there is no U.S. intervention here. I'm sorry. And if this judge reads this, the first question he's going to ask is, who the hell is the office of solicitor? That's what I would do if I was a judge. Who the hell is the office of solicitor? And I think what they're manipulating for is, so one of the things that the judge advised Miss Bell, the U.S. Attorney's Office in Albuquerque, was, you have some other options. Why don't you take the other options? And I think what it may be doing is a way to see if they could actually get a protective order through the government, the Department of Justice, that Miss Bell should be working on, but probably hasn't been able to swing it as of yet. Because this email is, let me put it this way. If this judge reads in detail this motion, he's going to deny it. He'll deny it because the basis for the motion is an email that has a lot of incorrect information about it. And this judge seems smart enough to know that there is no office of the solicitor, and that the citations there, if all he has to do is get on what the hell is the name of that place? LJI, Cornell Law School, and he can see that the citation. First of all, he's not going to find that citation, right? There is no 36 CFR 2031. There is nothing there. That's the mistake. It should be 2.31. And then the second one is Title 54 U.S. Code 10021, and not what did he say? 1000751. So I'm not even a judge. I'm not an attorney. I don't even pretend to be an attorney on TV, and I can already see the mistakes in this motion. And that kind of mistake, and there's no threat. Where's the threat? From the office of the solicitor? That office doesn't exist. And if it did exist, like I said, I'm starting to get repetitive. Anyway, if Matthew really wants to keep moving his case forward, and he actually reads this motion, I think he'll deny it, and I think the deposition will go forward. My opinion. Now, don't get me wrong. I still don't think we're going to find out where the treasure is, right? There is no, the threats here are, there is no threats. So here's problem number 5. If the government, if the office of solicitor under these two mistaken titles, codes, U.S. code, USC, and CFR, if the solicitor is going to threaten, which they didn't do, threaten Jack with punishing him under damages and supra, then you have to ask yourself, why didn't that happen in August 2020? When he told you exactly where it was, and you decided not to punish him. And there's kind of the case that Jack had to make. He said, wait a minute, you don't even have to have an agreement at this point. I gave you this information in August of 2020. I don't have an agreement with you, but why are you punishing me? Why are you threatening me with punishment now? And a good lawyer would prove that the government is way out of its bounds here. That if they didn't punish him back in 2020, then why the hell are they using it now? Because there is a chance he might reveal it. Now, I'm going to say, I don't think we'll get, even if the deposition does occur tomorrow, and even if Mr. McCracken uses all his wiles to get Jack to answer the question, I think Jack is smart enough not to answer the question. I think he has a variety of reasons, and he will force the issue because Summers, who's the one that asked to have Jack deposed, doesn't need any of that information. He's usually, all he needs for Jack to say is, I found it in Wyoming. That's all. And then McCracken can go on with all these other things. But again, I don't know how all these other things, whether it's the solve or the precise location or whatever, I don't see how that's relevant to Summers' case in front of the probate court. Yeah. But yeah, he can't toss. It's a probate case. It has to be heard. It has to be resolved. What he can do is tell. So Jack doesn't have a claim. The people that have a claim are already making claims. We've already seen several of them have been denied. I think the only possible action here in the long run is that he eventually denies McCracken's claim, but he can't do anything to Jack. Jack is a deposee. He's not a part of this case other than being a deposee. And he can't, the judge can say, I'm sorry, you have to tell us where it was. That attorney could defend, if he knew what the codes were, he could defend Jack not telling him where it was under the things that I've talked about in the past. So I don't know. I'll be surprised if the judge delays this based on what I read here, because I think he's a pretty smart guy. Anyway, man, it's 20 of 12, guys. Every time I try to get out, they pull me back in. I shouldn't be doing this. I really shouldn't. This has nothing to do with Forrest Fenn's treasure hunt. Um, that's where I was. I pivoted away, thankfully, with the help of my beautiful partner. I pivoted away. We wrote books. We're making money from clients, not just YouTube. So I don't know why I'm back here. I don't. Other than I see a motion like this with an email that's. I'm honestly, I'm going to say it's poorly written, poorly composed, with some significantly visible mistakes. And if the judge is wise at all, as he seems to me to have indicated in the past, he's going to deny this motion, and the deposition is going to go forward. But that doesn't. There's nothing in here that necessarily means Jack is going to reveal the things that he hasn't in the past. Because I think this threat. I don't think there is a threat here. I think the attorney is looking for things to make it sound like a threat, but you read that email. There is no threat in there, and I'll post it. It's too late for me now to start making file folders on Gmail. But let's see. Are there any questions? I haven't been paying attention. That's what Shelley does. So let's see. Toby, are you in a giant tanning booth? It looks like it. No, it's our studio. 3D Bronze, we have a studio, and there's two big 125 watt compact fluorescent bulbs over there on the wall coming down at me. And then there's two up here lighting the green screen behind me. So we like it bright. We like it bright. Let's see. All right. If I missed any questions, please ask them again, because I can't go all the way back. Or if you have any opinions to express. Bobby Hooley says, Toby, thank you for giving your opinion and giving us an update. Now, that also means, let me see, who says what? Toby, I actually heard 3D Bronze. I actually heard the Office of Frozen Yogurt. Oh, 3D, you comedy guy. So that means there will be other motions filed tomorrow. So if McCracken doesn't want the deposition to be delayed, he'll file a counter motion. That means it'll all be documented by Friday, so I should be able to get all that stuff and talk about it on Saturday night's show. But I got a feeling that the judge is going to have a hard time delaying this. If it doesn't do it tomorrow, if it's too late to do it tomorrow, he might just tell him, "Hey, I don't see any reason to stop this. Go forward with it," and then that attorney has to do a really good job of objecting. And the only thing that could change that is McCracken brings the transcript of the deposition and somehow makes a case that he didn't get the information to support his claim. And then he's got to justify to the judge why the precise location or the solution will support his case for a claim against the Fenn estate. I don't see how that works. Bobby, we are not doxing anybody. These are public documents. These are documents that will be filed with the court. The only thing that I'm hesitant to do is the last page, but this is not doxing. These people are public. These people are part of the court system, and their information is public. Then they actually have to publish their address and phone number in every motion. So it's public. Oh, is this something else? Sorry, you're talking about something else. Toby wasn't a reference. Yeah, sorry about that. Excuse me. I misinterpreted what was going on. All right, guys. Well, thanks for staying up late with me. It's not quite Church of the Search, but I would have done it earlier, but both Mike and Christy were on, and I didn't want to step on their toes. So let's see. Doesn't this give Jack cover to plead the fifth? So you can plead the fifth in a criminal case. This is a deposition for a probate case, so I don't think the fifth has any weight in here, right? And I think that's why you want the protective order. But again, if I was the judge and he tried to plead the fifth, I would say, where is the need for you're not. So you plead the fifth when you have the potential to incriminate yourself in a crime. There is no threat of incrimination here. The office of the solicitor doesn't exist. The codes that they cited don't exist. Now, that may be mistakes on his part, but I don't see how you can confuse the office of the solicitor with the office of the Solicitor General, who's responsible for Supreme Court cases, with the Department of Justice. That's either a real big mistake or a rushed conversation where he wrote down wrong stuff. So that's the first thing. The second thing is the judge had a hard time trying to let Miss Bell of the Department of Justice convince him that this was a real dangerous thing to do and it was going to damage properties. He said, "Sorry, I don't see what you're worried about." Right? He told her, "You have other avenues to handle this. Get your your one of your federal judges to file a I can't remember what he asked her to file, but they've already been through this. The judge hasn't been. He denied that motion to delay it so that the U.S. government could move forward with it. Here, it's like I said. So no, it doesn't give him cover because he's in a probate case, and because he can't be charged with a crime until he's charged with a crime. You're not admitting to a crime because you haven't been charged with anything. And that all depends on whether he agrees that I found it in the park. I don't think that's going to happen. I don't think he's going to say where he found it, except that he's going to say I found it in Wyoming. So, but I think I don't think this is going to wait till May 31st. I think the judge is going to ask, wait a minute, you want a what? And I could be wrong. You know me, wrong. Never write Toby. So I've been wrong about everything. So I could be wrong about this. But honestly, that dang email bugs me. It doesn't. It has a lot of things. Hang on. Let me turn this off for just a second. I want to go see if the email down below is. Yeah. The same mistakes are in the original email to Mr. Summer from Mr. Nasco through, there's some other people in here. There are some other, so I can't share these. I don't know who they are. Oh, different attorneys. Oh, interesting. So yeah, the email that he wrote to Summer, that Summer cited in the motion, it says the same. So there's something just dang wrong about that. United States Solicitor's Office doesn't exist, and if it did, and the closest that comes, like I said, is the Office of the Solicitor General, and it only defends the U.S. in Supreme Court cases. So I don't know. What does Bobby say? Oh, 3D bronze. Toby, how would he plead the fifth? He wouldn't be self-incriminating himself since he already confessed to the crime when he told the park where it was. Am I wrong? Yes, you would be wrong in assuming that he confessed to the crime. That assumes, and it's an assumption, it's conjecture, where if that he committed a crime, it's conjecture that it was on Yellowstone National Park property. That's conjecture, right? We don't have any evidence. We have hypothesis, we have assumptions, and we have conjecture. So, but let's say you're right. Let's say it was on Yellowstone Park property. If it was, why wasn't he charged with a crime back in August 2022? That's a case I keep trying to make. It bothers me, and I think if this email was actually of any value, you have to ask yourself, if he wasn't charged in 2020, back in August of 2020, how could they even insist on a charge now? But again, that would not be the Office of Solicitor, which doesn't exist. There's no such thing. It would be the Department of Justice and the Department of the Interior Legal Branch. Never charged. What and honestly, I still think this one, 36 CFR 2031, is not the one that would be cited. It would be CFR 36, Title 36 CFR 2.22, which is the abandoning of treasure and the digging of treasure in the park. This damages thing is where's the damages? And this is not the supra, right? This is the damage that was done by, but the abandonment of property that was done by Forrest Fenn, and the damage that was done by Jack Stoof when he dug up the treasure. And you could easily make a case that Jack didn't damage anything. He found a treasure. There was a 10-inch by 10-inch by 5-inch hole. He pulled the treasure out, and then I would challenge anybody, go find the damaged location. Because it strikes me that Jack would have been, he's a pretty smart guy, right? It strikes me that he would have been smart enough to backfill that hole. So it wasn't a big deal. So anyway, that's where I stand. Let's see. Mike says, if there is an agreement from August 2020 to not disclose, he can plead the fifth. No, he wouldn't have to plead the fifth because the agreement would be enough. The agreement, if he made an agreement that he would never reveal the location, and that agreement is in writing and signed off not by our friend Sarah Davis, but the Department of Justice, that would have to sign off. That's the only department that could provide that agreement and get him to sign it. Now, if he signed it, then again, it's the same thing applies. If he has an agreement with the federal government that says he can never reveal it, there's no way that the federal government can punish him for revealing it. So that's why I don't think the agreement exists. And that's why I don't think there was no agreement. There was, you look at it, August 2020, what comes out of the August 2020 meeting? Forrest goes back to preparing for his end of life. Jack goes about preparing for the sale of the treasure. And the U.S. Department, the National Park Service goes about its business finding Fenn treasure hunters that are screwing things up. Here's what didn't happen. Nobody was charged with any kind of crime. No agreement. There is no evidence of an agreement. That would be a public document that you could FOIA. There, to the best of our knowledge, there is no agreement. Conjecture that there was an agreement. And conjecture, if there was an agreement, then the government can't prosecute him now. He doesn't have to claim the fifth. All he has to do is hold up that agreement. I have an agreement with the federal government that they could not punish me for whatever damages I did, for whatever hole I dug up, because they said that if I told them where it was, they would not punish me in the future. That's why it doesn't make sense, at least to me. Let's see, if you admit to murder and haven't been charged, you'll be charged due to your confession and evidence. Yeah, that would be true. So what damage? Yeah, that's a good point. That's the other point that I keep making. If he's going to be charged under trespassing, 2.31, 31, what's the number? 36.231. Let me go back here. 36, 2.31A3. So 2.31, that's 36. It says up here, 36 CFR 2.31, not 2031. A.3, vandalism. That's what he said that he would be charged under. Vandalism. 36.2.3, yeah, A3. Doesn't make any sense. He should be charged for not returning property to the superintendent, not returning found property to the superintendent. That's the correct charge here. It is not vandalism, destroying, injuring, defacing, or damaging property or real property. The other day it was really funny because Cynthia had a video of her crossing the Madison and going into an area where she thought she was going to find what she calls the Nook, and she passed a tree with where somebody had carved his initials, JR, if I remember correctly. That's vandalism, and you could be charged with it. That's vandalism. That's not the law that applies to what Jack did. If it was in the national park, the law that would apply would be I'm sorry, 36 2.22. Let me see if I can find it for you. Part 2, 5.22. I think it's here. Property. Yeah. This is what both Forrest and so this is the same one, Title 36. And this is what they would have been charged on. The following are prohibited: abandoning property. That's a Class B misdemeanor. And then failing to turn in found property to the superintendent as soon as practicable. Well, he was there and he had the treasure. Practicable should have been that day. That's what he would have been charged. He would not be charged with vandalism. That makes no sense whatsoever to me. No vandalism here. JK Pioneer. JN. Thanks, JK Pioneer. JN. Yeah. And it looked like it had been recently carved too. It's very neatly carved. That's vandalism. You can be if a ranger walks up and sees you carving into one of his tree, he's going to sick one of his bears on you. I made that up. He wouldn't actually do that. Okay. I only saw X marks. Yeah. I was kind of worried about, well, I'm not going to bring that up. None of my business. None of my business. Okay. So I've expressed my opinion. I don't think there's enough in this. My opinion is, okay, but I have to modify that. So I don't think there's enough in this motion to delay to May 31st. Could be wrong. It's my opinion. I don't think there's enough in this motion to delay till 31st. And I still don't think Jack is going to share anything other than I found it in Wyoming. So there. So comment below if you don't agree with me. Let's see. What do you say? Toby already confessed, I'm not turning it in. The authorities already have his confession to that on record. So what crime would we be self-incriminating to? So again, 3D Bronze, you're making that assumption. You're assuming that based on the conjecture that it was hidden in Yellowstone National Park. If it wasn't hidden in Yellowstone National Park, that point is moot. Because if it was in BLM land, there is no requirement for him to turn the treasure into anybody. The only place that applies was in Yellowstone National Park. And he confessed it, but then if the confession is on record, you have to ask yourself, why was not he charged? He confessed to a crime. One that you and I both know Yellowstone National Park rangers take very seriously because it is preceded by the phrase forest fen treasure. So you claim he confessed that he committed a Class B misdemeanor to a ranger, but he walked and the confession. Thank you for confessing. That's not how police work works. That's not how they work. They don't thank you for confessing. They charge you with a crime, and they didn't. That's my point. So there. Yeah, Mary Green, it is. So the email that, so here's the deal. This is 2 places removed. Mr. Summer cited verbatim the email that Mr. Nasco sent to him. And he mentions here, see Exhibit A attached here too. That's this little thing down here. I'm not going to share that because it has personal information of people that to the best of my knowledge, I don't know how they're involved in the case. So I'm not going to share that. Now, it is an exact copy of that email. What it isn't is a copy of an email or a conversation that was had with a Department of Justice attorney. Because as I said, there is no such thing as the United States Solicitor's Office. Or is the Office of the Solicitor General, who deals only with Supreme Court cases. So I know that. Now, I spent a lot of time in Washington, D.C., but I'm willing to bet that Judge Matthew knows that as well. So he's going to ask some questions. I'm going to be surprised. He's going to say there are errors in your motion. You have a day to correct them. If not, the motion, the deposition proceeds as scheduled. I think there's a good chance. I don't know. I know nothing. What do I know? I'm not an attorney and I don't play one of you two. I just like to cover this stuff. And again, this motion hasn't been filed because it doesn't have the court's stamps on it and date and time stamps. They stamp it. You've seen the other motions that I've shown you. This one hasn't been filed. And I didn't read all of McCracken's writing. He said that he was going to, and I think Summer in here says, down after this, he said, Petitioner McCracken has publicly indicated he fully intends. The estate is no indication, estate and Stoof. Petitioner McCracken opposes this motion. So that means he'll file a motion opposing this motion. Hopefully he'll say why. Hopefully McCracken will have seen the same things that I see. There is no threat. The codes, the U.S. code and the CFR were both incorrectly cited, and there is no such thing as the United McCracken. If you're seeing this, use that. Say it's made up. So. Let's see. Marion says, if NPS went to look, could be at the border of BLM, and NPS could be anywhere. We still don't know. Everything that any one of us says about where the treasure is located is conjecture. There are only 2 people that know. I'm sorry. There are 5 people that know where the treasure was, and one of them is dead. And none of them are us. So it's anything we say about where it was located is pure conjecture, no evidence whatsoever. It's sometimes in some cases it's more than conjecture; it's hope. That's all we got. That's why I don't say precisely where it is, because I don't know precisely where it was. So, okay, guys, I think that's it for tonight. I'm going to go. It's too late to have a drink, so because that'll just keep me up all night. So I'm going to go watch a little, I don't know, something to relax me, and then some good documentary. Relax me. Then go to bed, and I will. So there's going to be a lot of activity over the next couple of days. I will go up on Friday afternoon, pick up all the documents I can, and we'll review them on Saturday and make more crazy conjectures and suppositions and assumptions. Okay. You guys have a good night. I didn't even do an intro, and I'm not going to do an outro. You guys do have a good night, and I'll see you on Saturday unless something explodes tomorrow. So, yeah, Shelly's gone tomorrow. So if something happens tomorrow and they list it on the docket, I may go up tomorrow and see if there's anything of value. I don't know. I'm certainly not going to do a Thursday night show. That's Mike and Christy's night. They do Thursday nights. I will keep mine to, I don't know. If it's big, I'll do one on Friday for the heck of it. Kind of an informal one on Friday. Okay. All right. Love you guys.